Today, we're going to talk about the defendant's motion to dismiss and how you can use it to your advantage. We want to talk about vetting the motion, really dissecting it and uncovering the gems that could help you advance your lawsuit. And I'm going to introduce you to 4 of those gems today. So let's get started. After you have received the defendant's motion to dismiss, you want to file a motion to stay the proceedings until the court has made a decision on the motion. You would contact the defendant, ask them if they would consent to a motion to stay. If they consent, you two would file a joint motion. If the defendants decline to consent, then you will file your own motion to stay. And now I want to talk about the 4 advantages I said I would introduce you to. Now, this is where vetting comes in. What is vetting? It's to make a careful and critical examination of something. And the motion to dismiss is one of those somethings. It requires that the pro se analyze the motion with critical thinking and analysis. This approach would help the pro se to understand what he or she is up against and how to respond. Now, the first advantage is that the defendant's motion to dismiss will disclose their defense, what they will defend, and what they will not defend. And at a minimum, the motion to dismiss will infer the defendant's legal theory or theories. The second advantage is that the defendant's motion to dismiss will cite applicable law. The motion itself will cite case law. I admonish you to read every case that the defendant cites. Why? It will help you understand the case and the defendant's defense, even though the cases were in favor of the defendant. Some of those cases will lead you to cases where the ruling was in favor of the plaintiff. And also, you'll get a feel of the strengths and weaknesses in your case, as well as the defendant's. And we're going to look at excerpts of a motion to dismiss to demonstrate this. Now, this is an actual and active case. And I'm not going to disclose the case because it is still active. And you will see where I have redacted the information to avoid disclosing the case. Now, as a consultant, I assisted the pro se with drafting the complaint. The defendants filed a motion to dismiss. The pro se responded. And let me say, he survived the motion to dismiss. He is still fighting the case today. Now, that ought to encourage you, pro se. So let's get to the real nitty-gritty of vetting and analyzing. Now, plaintiff filed 6 actions. The defendant filed a motion to dismiss 4 of them. Count 1, Title 7 and Section 1981, race discrimination. Count 2, Title 7 and Section 1981 retaliation. Count 3, negligent infliction of emotional distress. And count 6, emotional distress. Now, the first thing the pro se has accomplished is knowing that his causes of action 4 and 5 are not challenged and they will move forward. Now, this kind of news is good to a litigant. It's good news, and particularly a pro se, because the individual is thinking, now I got a fighting chance. Now, let's look further at counts 1 and 2. Now, the defendants asked the court to dismiss counts 1 through 3, and I want to focus on counts 1 and 2. They asked that the counts 1 and 2 be dismissed for failure to state a claim upon which relief can be granted because the company is not and has never been plaintiff's employer. And they base this on the pro se putting one of its subsidiary names in the caption among many names that it used. Now, my analysis was that it was fixable. Defendants knew their argument was a weak one, and perhaps they were grasping for straws because they knew that the defendant had merely named the wrong name. Thus, the defendants knew that the pro se had sufficiently put them on notice that they were being sued pursuant to Federal Rules of Civil Procedure 8. In fact, the court permitted the pro se to amend his complaint to fully state the defendant's correct name in the caption of the complaint. For me, this was a signal that defendants realized the strength in these two counts and also verified the strength and verified my belief and pro se's belief that there was strength or merit in those counts. Of course, that belief was confirmed when the court permitted the pro se to amend his complaint. Now, another thing that caused me to question whether the defendant actually believed what they were arguing is the fact that they cited only one case law to argue against the pro se's causes of action 1 and 2. Now, of course, when the defendant asked the court to dismiss causes of action, they must cite case law in their argument. And in this case, the defendant cited only one case. Now, I'm not suggesting that one case law would not be sufficient to convince a court to dismiss a case for causes of action, but the case that the defendant cited was a footnote concerning a procedural matter, one that was explainable and ultimately had no effect on whether the pro se identified defendants as his employer. Ability to amend the complaint. Hone in on what the defendant is attempting to get dismissed. If it's fixable, fix it, amend it. Remember, in this case, the court permitted the pro se to amend the complaint to more fully show the company as his employer. And remember, pro se, of the 7 defenses, the one that cannot be waived is 1, lack of subject matter jurisdiction. And the 4th advantage is preparing and propounding discovery. Pro se, as you are reading the motion to dismiss and a statement or sentence triggers a potential interrogatory or deposition question, stop your reading and write the question down. For example, let's say you are reading a statement that contradicts information you have. Stop and construct a potential discovery question for impeachment purposes. This type of stop and take down should happen at every phase of your lawsuit so that when time comes to propound discovery, you'll be 75% ahead of yourself. Here's the deal: that every word in every sentence. I trust this video has really been helpful to you. I am Advocate Lucinda, your empowerment lawyer. We'll see you next time. Take care.